Mr. Wishart tells you that he, again, has already completed the high conflict children in between parenting seminar. And we've provided proof of that. So that's giving him additional tools. And then by virtue of having these folks communicate through our family wizard, that's going to hopefully eliminate his need to react to Ms. Wishart. In regards to the substance abuse treatment, my client indicates that he will definitely participate in the substance abuse treatment. The amount that was quoted, and I apologize again because I didn't get that in my notes this morning, my recollection was that it was around $1,500. And he is checking with his medical provider at Kaiser to determine if they can provide for that same treatment and hopefully maybe have it covered by insurance. So he will certainly follow through on that. The suggestion that Mr. Wishart should undergo weekly UAs, that's one of the recommendations from the guardian ad litem. Mr. Wishart is already financially tapped. At this point, none of the supervisors, the professional supervisor or the lay supervisor, have had to intervene in a visit, nor have they reported Mr. Wishart appearing to be under the influence. Obviously, the current parenting plan provides for that. Well, the supervised visitation rules provide for the supervisors to terminate a visit or to not start a visit if they believe that he's under the influence or if he is acting inappropriately. As well as Ms. Wishart has the ability to request for random UAs and hair follicles, and at this juncture, under this temporary order, she's not done so. The cost for UAs, depending upon how many panels you run, are going to be anywhere from probably $35 on up. But we have a situation where we have a gentleman who does not have the finances to continue to provide for all of these things. So I would ask that the court not adopt the GAL's recommendation on the weekly UAs. That certainly seems overboard, particularly in line with an evaluation that is recommending 1 month of treatment and then a review. So it sounds to me that he's already on a clearer path. And we believe that that should be the substance of what he should do, is to complete the substance abuse evaluation, the treatment that was recommended. And again, if that is through Awakenings, that's going to be roughly $1,500. So we'll need time to be able to provide payment for that. In regards to the financial circumstances, as my client tells you, and he's provided his wage stubs for the last month, and in the month of June, he had to pay $290 for the orientation and for the 2 supervised visits. He paid $200 for the Awakenings evaluation, $150 for the high conflict children in between 8-hour parenting seminar, and $550 for Olivia Lovely's domestic violence evaluation. So from his net for the month of June, he netted $4,871.53. He paid $2,000 to Ms. Wishart, the $900 for child support and $1,100 for spousal maintenance. He's ordered to pay his car payment and her car payment. So his car payment is $526, her car payment is $325. He's ordered to pay the family health insurance of $538.71 per month. And he's also ordered to pay Ms. Wishart's automobile insurance. And at this juncture, all he's gotten is handwritten documentation of her claim of what her automobile insurance is. We need actual documentation from the insurance company as it relates, but regardless, he went ahead and paid the $109. And so for the month of June, that left him a whopping $182.82 to cover his fuel to go back and forth to Kalama for employment, to cover his food, to cover his now app for the Our Family Wizard, to cover treatment classes if the court's going to order those. He is completely tapped. And so we're asking again at this juncture that the court terminate the $1,100 per month spousal maintenance. This is a short-term marriage. While the guardian ad litem report says that there's an inclination that Ms. Wishart wants to either attend a dental hygienist or I think it was nursing assistant, one of those two educational programs, there is no information that she's provided under sworn declaration to this court about any efforts at securing employment or pursuing educational opportunities. My client needs some financial relief so that we can move forward, if anything, with regards to the substance abuse treatment, so that he can pay for that if he has to do that through Awakenings. So that's the relief that we're asking. We are asking that the court consider unsupervising visitation and setting a schedule. Ms. Kale suggests that visitations need to be arranged a week in advance. We need a schedule. Normal parenting plans have a schedule that everybody can look at, that the court can easily enforce. So we're asking the court to set a standard schedule and to provide for unsupervised visitation, because again, there's nothing in any of the supervised visitation notes. And quite frankly, there's nothing in the guardian ad litem report that suggests that Mr. Wishard's parenting is negative or inappropriate for his daughter.
All right. Thank you, Ms. McLean. Ms. Baldwin.
Thank you. In this case, we're largely in agreement with the recommendations by the guardian ad litem. But when you look at the guardian ad litem report, I think that that's the best place that you really see a pattern of deceit on the part of the petitioner. Initially, when he came to the court, essentially denied drug use, saying, don't test me, that would be invasive, but trust me, I'm clean. And what do we come to find out? That he's positive for illegal substances. He denies that there's any kind of problem with alcohol, but what do we find out? He's drinking the day of his substance use evaluation. He's drinking the day that he's having a visit with his own child. So we have his positive alcohol test on the same day as both the evaluation as well as the day of his visit. So again, dishonest. We see him denying issues of domestic violence, but yet we have pictures of holes in the walls and him making statements like, I'll allow her to go do this, or, I authorized her to do that. So again, we have these repeated instances, him denying prior use of narcotics, and then when caught in that lie, finally admitting it to the guardian ad litem. That is a pattern of dishonesty with the court and essentially with everybody in this case. When we look at that, I think that that's the place to start, is we have one party who's not being genuine with the court and one party who is. When we think about supervision, the court really has to clarify this. And even the guardian ad litem is sort of a good fences make good neighbors, and we would tend to agree. Again, we have Mr. Wishard drinking or under the influence of alcohol, and we know it because we have that positive alcohol test. And his family right now has been the only one to supervise other than the initial 2 visits, I think, with Ms. Fellows. And do they report anything? Sure don't. And that's the problem, is you need to be able to trust these people. And we have a positive alcohol test that shows he's under the influence at a visit, not a word. These are the very concerns that my client had, is that when only one side is providing the supervision, you get this very skewed result of the, hey, there's no problems, nothing going on. Because unfortunately, parties have a tendency to have their families gloss over those types of issues. And again, ignoring the fact that there's a positive alcohol test the same day as the visit. So the court's really getting a false narrative with sort of everything's delightful, everything's good. But again, we have black and white evidence that that's just not the case. So again, my client, she's not against his family supervising at all. She wants it to sort of be even Steven, in the sense that Mr.'s family supervises, my client's family supervises, and that way there's sort of an evening out of the reports that are involved. What I'd ask the court to do is, there seems to be no problem with Mr. Supervisor and their schedule availability. I'd ask the court to allow my client to choose 3 additional people from her initial list to provide supervision, but that those people not be her direct parents. I understand there's an issue with her parents, that's fine, but that she be allowed to choose 3 additional people, because this looks like this is a long-term issue, and that's reasonable to have a series of 4 total people on my client's side that can provide that supervision. And that supervision should alternate. That's what the expectation is. That's why we discussed it. That's why we discussed that Mr. couldn't dictate where visits were going to occur, because the expectation was that we were going to have my client's family supervised. We talked about having reports from both sides. So again, that's appropriate that it alternate. When we look at that, the guardian ad litem says things need to be arranged a week in advance. We agree. My client's already logged on and has our family wizard. My understanding is the party's already communicating that way, so we're in agreement with that. As far as location, again, court saw from the documents, Mr. basically says my way or the highway. That doesn't work. So we're asking the court to just say my client supervisors provide 3 locations. He has to pick one, because otherwise this idea that he has to agree, then he just won't. And then sort of by veto power gets to dictate the location, which the court already says I'm not going to let him do that. We've already had that discussion. Unfortunately, the way we worded it, Mr. found that he could just veto everything. So that's not appropriate. In this case, the court should at this point make the finding of domestic violence in the parenting plan and make the finding as to Mr.'s substance abuse problem. We do have the domestic violence evaluation. It does find that there's domestic violence. There's a need for treatment. We have the guardian ad litem, who actually did an amazing job for an interim report that was very thorough. But even she says, yeah, things were not appropriate. He was doing things that were not appropriate. There was advantages being taken. He's putting holes in walls. And so with all of those pieces of evidence, the domestic violence finding is appropriate at this time. It is appropriate that he be required to do domestic violence treatment as recommended. Mrs. Lovely is not the only provider. Mr. can certainly find another provider. I'm fine with any Washington state licensed provider. I don't want it to be, some random person from Florida, but so long as they're licensed in Washington, that's fine. So that takes out any sort of these scheduling issue problems that he wants to claim. But again, when you take the photos of the domestic violence, you have photos of holes in the walls, you have the text messages between the parties where he talks about, I lose my temper and it's your fault. I've allowed her to do this. I've allowed her to be out of the house. All of those are very fundamentally domestic violence issues, and he should be required to attend treatment as recommended. So we have the evaluations. It's because we're not experts. We rely on the expert to say what's needed. She's outlined what's needed. He should be required to comply. As far as substance abuse, again, we have an evaluation. My concern here is a bit that the evaluation sort of glosses over the fact that he showed up with alcohol on board. It says that he wasn't inebriated at the evaluation, but sort of ignores the fact that he had a positive UA. So I think that there's a little bit of a concern there, a concern that he's really not amenable to treatment in the domestic violence realm or the substance abuse realm. Both are sort of like, hey, this isn't really a problem when everyone else says it is a problem. So we are asking that he be required to comply with substance abuse treatment as recommended. Additionally, the court should order that he's required to abstain from all substances, including alcohol, period, full stop, end of story. In this case, that's also what the evaluations and recommendations seem to be, that he not use any substances. That should include alcohol. That should not be time limited at this point in this court order. We're asking that he be required to do the UAs as recommended by the GAL. We have certain substances he's been positive for. He doesn't need the most extensive UA possible. I think the standard lower panels are going to catch marijuana, alcohol, and opiates and cocaine. I think that those lower panels are going to be fine. Those are relatively cheap as a once a week type of cost. So again, I think those are appropriate, and they're appropriate to protect the child. The idea of putting the financial burden on my client when she's not the party that's sort of offended and been dishonest with the court, that's just not appropriate. He should be required, at least at this point, to provide those up front. As far as mental health, the GAL also recommends my client's in treatment. I think that's reasonable. She's been through a domestic violence situation. She's getting education and knowledge and counseling to help her not end up in that situation again. The report specifically said that Mr. had some issues with mental health, either a potential PTSD diagnosis or an anxiety and depression diagnosis. But again, he didn't have those specific evaluations. Those are just subsets of the evaluations that are done to sort of look for other markers of other problems. He should be required to submit to a mental health evaluation and treatment. I'm not asking for a full psychological evaluation. I'm just asking that he be required to meet with his physician, take the appropriate assessments that are essentially free to him through his insurance, and follow up with any treatment that's recommended. Again, my client's not interested in causing barriers for him. She's interested in him being a healthy and whole parent who can be a benefit to their child. He can't do that if he's not mentally healthy, clean from substances, and has a better understanding of domestic violence and his own entitlement. The next issue that's really addressed is costs. Council lays out cost after cost. It's a one-time cost and is not a continuing cost. It's sort of like take this one-time thing that happened and now overlay that over all the months in the future. That's not appropriate. As of May, if you were to take that wage stub, so that wage stub is essentially pay through May. Its pay date is in the first week of June, but it's pay through May. He had gross income of $7,654. If you were to look at his original financial declaration, he said he had gross pay of $7,989. Not very far different. That's his own words that he said that he was making. So given that, he does have plenty of income to meet his expenses, and he has zero expenses, essentially, other than the court-ordered ones. He's living with his parents. He's not paying any rent. He's not paying any utilities. He's basically making a handful of fairly small payments to maintain health insurance and vehicles for the parties, and then paying court-ordered things. That's appropriate. That's getting him healthy at this time. He has the funds to do it. His statements that he's tapped, they just aren't borne out by the evidence. There's no cost for supervision based on how the court's orchestrated things. So again, not appropriate. He should be required to do the services that the court has ordered. As far as financial, the court should make no changes in the current financial orders and obligations. And the court should cease and terminate further just automatic reviews that it can just be reviewed and tacked on to any other argument. That's not appropriate. When you look at Mrs., she was a stay-at-home parent. She had lost her licensing and credentialing to be able to go back to work. And again, when you look at the situation as a whole, when Mr.'s words again ring true, I allowed her to. The expectation that she be a stay-at-home parent, that she let those licenses lapse and not return to work. My client's now saying, okay, here's what it takes for me to get relicensed. Here's the school I'm going to. And she does provide that information for you. That's in her declaration under the spousal support section. And she provides exhibits as to those costs. The costs are somewhat modest, but there's time involved in her being able to take those classes, pay those funds. My client's not asking more to be able to pay for that education that's necessary for her to get re-credentialed. But she's also saying it takes time, and I need the support to be able to bridge through this situation to get to a place where I can make a reasonable outcome. And again, that's reasonable in this case. When we think about that, she stopped her education. She was going into a nursing degree, not dental, but she had a CNA, again, lost that credentialing because she was a stay-at-home parent. But at this point, being able to support herself and the child at a livable wage is a long-term benefit to everyone involved. Mr. has the ability, Mrs. has the need. It's reasonable in this case, and there's a long-term benefit for the mother and the child for a short-term spousal support that's being provided now. And again, these are temporary orders. So my client's asking that the financial orders remain the same. And again, Mr. hasn't provided a financial declaration saying he's not able. He's just saying that because that's the easiest way to reduce the support. But he really hasn't provided documentation that would actually financially show that. So given that, my client is asking that the court not make any changes to financial orders. Other than that, I believe that, again, the guardian ad litem has done a wonderful job at an interim order on a very short-term basis. But we do have, at this point, expert reports. We have the report of the guardian ad litem. The court should, again, largely follow the guardian ad litem's recommendations with the small changes that we've requested to provide clarity to everyone.
Right. Ms. McLean, anything briefly?
Just briefly, I would indicate that there is absolutely no proof that he drank the day of the substance abuse evaluation. ETG typically runs for 72 hours, so it'll test up to 72 hours. And I would like to see the expert who would suggest that that test results concludes, as counsel is claiming, that it shows that he was drinking the day of. Had he shown up for the evaluation with alcohol, that would have been noted. Had he shown up for visitation with alcohol in his system, there wouldn't have been a visitation that would have taken place because that would have been in violation of the supervision rules. In regards to the suggestion that, or the language that's attributed to Mr. Wishart of, I allowed her to do this, I allowed her to do that. There's absolutely no allegation that he was isolationist. There is, maybe he is a poor speaker, and that certainly was not what his intention was. Again, there's been no allegation that he's been isolationist during their relationship. In regards to the suggestion that there should be a finding of DV, you have a specific declaration from the DV evaluator who states that Mr. Wishart is not the aggressor. Mr. Wishart has not been the aggressor in this instance. He has been reactive. He's been reactive primarily to Ms. Wishart's behavior directed towards him. And if anything, that he could use some counseling as it relates to interpersonal relationships. That does not equate to domestic violence. So we do not believe that this is required for a domestic violence finding. And I would also ask, I'm not aware of any other state certified domestic violence counselors in Cowlitz County. So that's a huge concern. I mean, how do we accomplish this if the court's going to order treatment for an individual who has scored in low profile ranges on everything except for the substance abuse? And we agree that the substance abuse should be addressed and will be addressed. My records show that a 5-panel instant UA is $40. So $40 a week is significant given his current financial circumstances. Again, I remind the court, Ms. Wishart is living at home. She doesn't have a rent payment. She doesn't have a utility payment. She's got her car payment, her health insurance, everything being paid by Mr. Wishart. So she does not have a need. She's already received, I think under the orders now, $3,300 in spousal maintenance that clearly covers whatever she is claiming as far as costs for these certificates. If it's $1,500, I think counsel indicated, she's had more than double the amount to be able to get that started. So our position is, again, very short-term marriage. She has the ability to go out, even getting a minimum wage job to supplement her living expenses. Her parents are at home and can provide care for the child. So she's not done anything to improve her circumstances. She's simply demanding that Mr. Wishart continue to provide for essentially 2 different households and a child as well, and then services and visitation expenses and the like. So we're asking that the court adopt the relief that we've requested.
Right. Thank you. Ms. Gale, anything you would like to add or clarify?
I don't know that I need to offer any clarification. I feel like I said what I needed to say in the report. My biggest concerns that I want to highlight are the inconsistencies that were shared with me in my interview with Mr. Wishart. When I was able to go back and ask direct questions regarding information I received from other people, he would change the information he had given me previously. I was also concerned about consistent substances showing up on tests when he knew he was going to be tested. To me, you know, the reason why I'm asking for that regular testing is because of the dishonesty and inconsistency.
I want to thank you that I would agree with Ms. Baldwin, and I think Ms. McLean noted as well, that's a very thorough interim report. We don't get interim reports that are kind of that extensive. So I appreciate the work that you've done thus far on this case.
Thank you, Your Honor. I find it helps with the final report if the interim's a little more, it helps complete the picture by the end of the process.
I'm sure it does. All right, thank you. All right, so I'm going to address the family support issue first. I don't want to continue having these just sort of be always the financial impact being reviewed on a regular basis. So what I'm going to do is starting September 1st for 4 months, family support will be ordered in the amount of $1,500.
Are you maintaining the $900 as child support?
Yes. And that'll go for 4 months. And then thereafter, it will be used the child support and all the bills and insurance as previously ordered. Obviously, if there's any dramatic change in circumstances, the parties are free to raise that again. But I do consider the circumstances that this is a relatively short-term marriage. Both parties are living at home, so there is some benefit to them. But I don't want to assume that means that everything is just being given to them as far as what is happening at home. So that's that. Our family wizard, I don't remember Ms. Baldwin touching base on that. Frankly, I don't ever see any harm in ordering that. I think it's kind of just a safety net for both parties to be able to communicate through that. There's scheduling functions on that app that can be very helpful to the parties to notify others of upcoming things or block out time. So I will order our family wizard. As far as clarifying the order of the court, I'm a little frustrated because it seems to me to be relatively clear. There is no back and forth. He was ordered the 4 hours a week. If only one side's supervisor can accommodate that, then that's who should do it. If that's uneven, then that's uneven. I would agree. Ideally, there would be an equal opportunity for both parties supervisors to be involved in that process. And I would hope that they continue to try to move forward in that regard. There doesn't need to be a back and forth. So if it's Mr. Wishard's this week, next week doesn't have to be Miss Wishard's. Every week, Mr. Wishard gets his supervision period. So if the only person available and the timeframes available is someone that's on Mr. Wishard's list, then that's how it is. So I would like to move towards considering unsupervised visitation. And I was, frankly, before I got some of the information for today, was hoping that that would be the court's ruling today. My concern, and one of the things that I specifically wrote down before we got started this morning, was the UAs. In the comments to the GAL, there was a claim, I've only ever done cocaine once. Well, that's interesting that it just so happened to be right before you got a hair follicle test, such that it showed to the levels that were there. And then going to get, I'm assuming Mr. Wishard set up his own drug and alcohol evaluation and clearly had alcohol at some point surrounding that, enough that it showed up on the UA there. I would agree with Ms. McLean. I can't sit here and say based on those levels that meant that he drank before the evaluation or had drank the same day as that visitation. I think it was the 13th of June that the collection was made at the UA was collected, and he also had a visitation that day. Is it concerning? Yes. Does it definitively say, oh, we know he was drinking on a day of a visitation? No, I'm not going to sit here and make that claim. Retrograde extrapolation could tell us otherwise, but I'm not. It's been a while since I've dabbled in that math, so I'm not going to sit here and say that I know that. Do I understand why Ms. Baldwin's concerned with that? Absolutely, I do, because that clearly seems to be the recurring issue. In reading Ms. Lovely's report, frankly, she put substance abuse as frankly a bigger issue than the domestic violence issue. And what I think we're experiencing is someone that hasn't been held accountable in regards to that and doesn't want to admit that there probably is an issue here. Frankly, I do not think that if it is $40, I know Ms. Baldwin indicated she felt there were potentially options available less than $40 for the UAs. I think Mr. Wishard has the funds to do that. I frankly also think that it's a small price to pay to ensure you're seeing your child. I'd like to see Mr. Wishard get started with substance abuse, and frankly, I'm putting that on the forefront. I'm not convinced that domestic violence isn't an issue, but I'm frankly more concerned at this point with substance abuse and keeping that in check. So at this point, everything's going to remain the same, but I'm going to allow for up to 6 hours a week of visitation that is supervised. I am going to require the parties schedule that as far in advance as they can. If they can do several weeks in a row and plan out far, that's great. I'm not going to sit here and go through Mr. Wishard's calendar and try to dictate those times as much as I'm sure the parties would appreciate it if I could. There's too many factors there and too many other folks that are giving their time up to help supervise that in their schedules. So if it can be an equal share of supervisors from both parties, that's great. If not, then he gets his time. He gets his time. I don't really care who it's with. And I'd like to see this. I'd like to see the substance abuse treatment started, and I'm going to order the weekly UAs as well. So those need to be done prior to the visitation at any point. So, and I'm not going to require that you return to court for a positive UA, but that will suspend that week's visitation. So then he gets another try the next week. I don't want significant delays in the visitation because of a positive UA, but he essentially would forfeit that week's visitation.
So let me ask you a question on that.
Yes.
I'm just thinking logistics. So I know that typically when I send a client over to get a UA, I will get results back either 2 to 3, maybe 5 days later. So if we are, let's say we're coordinating a visit his last day off. If he does that, his first day off, because he's got 4 days off, if he takes it his first day off, or maybe he takes it on the interim between when he transitions from day shift to graveyard shift, he's got like a 24-hour period there, have him do the UA there, and then hope that we've got the results back.
Ms. Baldwin, do you have any? I don't want to hinder, like I don't want him to miss a week's worth of visitation because the UA doesn't come back.
Right.
And I don't know my experience with instant UAs, and I don't know if there's people that do instant UAs because they can be a little bit wonky, but you generally don't get levels with those, right? You just get a yay or nay. And I don't know if anybody does instance and how many panels there are in instance.
So Performance Occupational Health, their fee schedule, it looks like they do, they call them rapid 5-panel drug screens for $70. And then it says, if you want to add a drug screen ETUG, which is for the alcohol, then the cost is $70. So if you're wanting alcohol, then you're looking at $70 a drug screen through Longview's Performance Occupational Health, which is the agency that we typically use. They're over on Hudson Street.
So
Okay.
I don't think he has to use the rapid so that he's sort of paying to expedite. My thought is that he'd be required to do it once a week, and ideally the results are back. If for some reason they're not back, the presumption should be the visit will progress as ordered, even if the results are not back. But if it's positive, he would then miss the next visit as sort of like, hey, you were positive, you shouldn't have had that visit. You need to think like sort of an automatic consequence for him. I think that that's a way to manage that without, absent him being overtly under the influence. That's a reasonable way to manage that problem and not require an expedited test result or an insta read, which is sort of not as quality as having an actual eval.
Well, I can't talk today. There is not a delineation in, they either have hair panels or they have these rapid 5-panel drug screen, 10-panel. These are all rapid, 5-panel, 10-panel, 12-panel, or they have a drug screen ETUG urine alcohol.
Right, but if he's doing substance use treatment, he should be getting UAs through that treatment. That treatment's likely to be covered by his insurance because it, I think, is required to be. So I don't think that he'll have to have them done through performance health or occupational health on a long-term basis because he should be doing them with his substance use treatment.
Okay. So what I'm hearing is that it needs to be done once a week.
Well, and usually they'll do once a week, if not more, if you're in treatment. And I know that he's looking at potentially going through Kaiser for treatment. So there may be a gap in starting that process. But I think I like Ms. Baldwin's suggestion. So he should just start doing weeklies. And we're hoping that there was as far away from the scheduled visitation as possible, with the hopes that that returns in time. If it doesn't return, presumption is he still gets his visitation. If we find out after there's a positive, then the next week would be suspended. And then, but we keep going that route.
And do we think that the treatment provider will provide that on a weekly basis? I mean, will they produce the results to us?
I would assume that if he did an ROI with them and asked that they provide it to you,
Okay.
that's, if he can get it through treatment, and I wouldn't I'm
Sure.
fine with it just being through that place and used for both services. So we
Okay.
don't have to pay for that.
Okay.
Historically,
great.
if he's doing the treatment with Kaiser, it'll show up in his test results. And so he should be able to print it out himself. If not, do an ROI and have them
Okay.
send it direct.
Okay, great. Thanks.
As for, there's a couple other. So Ms. Baldwin's requesting that the 191 factors for substance abuse and DV are found now. Frankly, I think there's a pretty decent argument for a finding of 191 for substance abuse now. I just always am hesitant to do that prior to trial. So I am clearly putting Mr. Wishart through the paces here, and I'm not, but I'm going to still reserve on the 191 factors, even though, frankly, that's the main concern of the court. As far as mental health evaluation by Mr. Wishart and some treatment, I don't think that is a bad idea. There was a reference in Miss Lovely's report to some PTSD, and I think there was potentially reference to some other
Anxiety, I think it was.
Yeah,
okay.
anxiety and depression.
I think it probably would behoove Mr. Wishart to address those issues. I'm not going to specifically order that he must undergo those evaluations, but Mr. Wishart should understand that if he does start attending any kind of mental health treatment and in the court finds about that, that's only going to be benefit him, not only personally, but I think likely in the scenario that we're in here. Is there any other issues that we needed to touch base on? I believe I addressed everyone's concerns. If there's something else, please let me know.
So on the supervision, so this is what will crop up. And if you can clarify, my client says my supervisor is available and willing, and Mr. says, nope, I only want to use my people. So if Mrs.'s supervision providers are available and willing, then does Mr. just get to say, no, I'm going to go with my person, and I'm just always going to go with my person?
Ideally, I think they should both be utilized. Do I want to sit here? And this is a little bit of a frustration that, and I'm glad that both Mr. Wishart, Miss Wishart are here right now. You are adults with a child. You're going to need to navigate this without the court's intervention eventually. So please, this isn't a, I'm going to win this fight, you're going to win this fight thing. This is a child that you're talking about. And that clearly, based on everything I've seen, you both care about very much, and your extended families care about them very much. This little girl needs to have all of these people in her life, and it's probably to her benefit that she sees other family members of mom and other family members of dad, especially during this kind of weird transition phase that everybody's in. So my biggest first concern is that he gets his visitation. My second concern is that there is some equality in doing that. Mr. Wishart, if you just say no, that's frustrating. And Miss Wishart, if you say no because you're not using mine, that's frustrating. So I don't want to see that moving forward. I don't want to say, well, it has to be, the odd weeks hers, the even weeks his, because what if that can't happen one week and then the other party decides to say, guess what? You don't get visitation because that's what the judge says. That's the situation I want to avoid. So, to quote a judge, I don't want to split Tupperware and have one party end up with 4 lids and no bowls. There needs to be some give and take here, and neither of you have the upper hand in this situation, because if you're going to make it difficult, then guess what? The court's going to make it difficult, and then you're going to have to follow very specific things. So my ideal is that you work this out. If for some reason someone has difficulty doing that, then I will dictate a very specific schedule with very specific supervisors, and that nobody's probably going to be happy with. And I don't want to do that, because I want you to work this out, because like I said, you're going to have to do it yourself eventually. So no. So the answer, long story, no, he can't just say, no, I'm not doing that because my sister's available. Let's have some give and take. That's my hope. If we have to deal with this again, like I said, then we're going to go down a path that I hope nobody wants to go down and that you're all willing to work a little bit more to avoid.
So is it fair to use language in the order that says the expectation is that it alternate unless the supervisor isn't available, and then it'll default to the other supervisor to ensure a visit happens?
I think that's fair. Does that work for you, Ms. McLean?
Okay, so what's the language?
So the expectation is that supervisors alternate between the parents, but if a supervisor is not available, then the other supervisor may be used to ensure the visit occurs.
That's the court's order.
All right. Anything else for today?
Just looking for the GAL's recommendation. Is the court ordering abstinence from all substances for Mr. Wishford? That he not use alcohol or anything at this point?
He needs to do a substance abuse treatment, and by way of that would be he's not using substances. And I guess as a catch-all as well, I would adopt the other recommendations of the GAL as far as corporal punishment.
I think that's already.
Yeah,
I think the current
All
order
that
has
the standard stuff, no negative disparaging comments. And I think that was in our temporary order, but I just wanted to ensure, since
So
the stick came up a few times in some different comments, so no corporal punishment.
I think that the current language on substance use is 8. I think it's 8 hours or maybe 12 hours prior to. I don't have that sitting right here in front of me, but
24.
oh, is it 24?
Yeah. But again, if the court's, so again, I want to clarify, so it's not, there isn't confusion later. So the court's saying because he's doing substance use treatments, you should abstain from all mind altering substances. And I think that's what the guardian ad litem also recommends.
I will adopt that at this point.
Okay. And I think with that, the other things are already, I agree with some of the other recommendations for the GAL are already in the last order, so that wouldn't be a change.
Okay, so then presentation.
August 1 is open for me as well, so we'll set it to 8/1/23 at 1:00 p.m.
Thank you.
Thank you.
All right.
Thanks for
Good
the
luck,
court.
everyone. Thank you.